down just a little.
I'm sorry. I'm trying to get it over with, so I'm sorry. Sorry, Chris. While we're on expert testimony, EDTA, very, very briefly, okay? You were told during argument that a letter was sent to Agent Martz asking him to refute the allegation that the blood was planted. That is not what the letter says. The letter says, I didn't bring the exhibit number, Your Honor, I just have the letter.
Supply that for us. All right. Why don't you all right. Proceed.
The question posed was, we would like you to test these items for the presence/absence of EDTA in order to refute the possibility that the stain on the sock could have come from this reference sample. Now, what is the point of that? When we heard that the defense was going to make this outrageous allegation, I thought, well, I won't close my mind to anything. Let's find out. Right.
Be careful here.
Okay. So we sent the reference samples, and we sent the sock, and we sent the rear gate samples to Agent Martz for testing. Let's find out. And what was the result? No EDTA. No big surprise, but no EDTA. Now, he came in and he testified, and he showed you these charts. And I want to show them to you one more time, because it made it so clear. And perhaps you may recall, he tested his own blood, unpreserved. He tested the evidence on the gate, and he tested the blood on the sock. And guess what? His own unpreserved blood and the gate stain and the sock stain all came out looking the same. They came out looking like this. We taped all their charts together, so what you see here is the results of all of those things. That's 544E, Your Honor.
Thank you.
Okay? That was Agent Martz's own blood and the evidence. That means the rear gate blood and the sock blood. That's what that looked like. So unpreserved blood and the evidence had all those jagged peaks. Okay? Here's 544F. This is what it looks like when we have EDTA preserved blood. All the same. That stuff all comes from the test tube with EDTA in it. Does that look anything like the jagged peaks that we just showed you? That's pretty easy. But Dr. Reeders thought he could get you to blind your eyes and listen to his title and say, well, gee, I'm not qualified. Maybe they do look alike. I mean, it's ridiculous, but he did that. And he insults your intelligence with this. But what's even worse, and what shows you really that this is a man whose opinion is for sale, is that his initial report said, I found 2 of the 3 ions on the gate and on the sock. And he thought that was going to be good enough for him to say, well, could be consistent with, and he could slide around with that. One unfortunate thing that happened after he wrote that report was, Agent Martz then said, gosh, I wonder what it would be like if I tested my own blood without any EDTA in it. Took blood out of his arm, and he went and he tested it with not an EDTA, just regular old blood. And guess what? It looked just like the gate. It looked just like the sock. Well, when Dr. Reeders found that out, he realized, I've got to do something, because they've just proven me completely wrong. So what he did for the first time on the witness stand was, he got up there and he said, oops, I found another ion on the sock. And he tried to show you that one of those peaks matches something else. It was really reprehensible. And I know I got a little bit excited with Dr. Reeders, but this is a man, does not forget where he comes from, does not forget what he did before. I asked him questions about this other case, the case of poisoning. You may recall, case of oleander poisoning, in which he was asked by the district attorneys of Ventura County and this county to find out whether a man died of natural causes or had been poisoned to death. Now, that sounds pretty serious, doesn't it? That's a murder charge that can or cannot be brought based on what his test shows. And he did preliminary screening tests. He did not use state-of-the-art. He didn't even know what state-of-the-art was available at the time. And he came back with the answer, yes, poison is present. Poison is present. And had the DA and the defense attorney not joined together to go out and find an expert who had much more sophisticated equipment who could do definitive testing, an innocent man would have gone to prison for murder. Because Dr. Reeders was so sloppy and so out of date and had an opinion for hire for whoever was bidding, that's what would have happened. But fortunately, the DA said, no, we're going to go and check that again.
Counsel, that does go beyond the scope.
And that's why you have to view very, very carefully the experts. See if they make sense. See if you can rely on them. See if they are believable. See if they are logical. And consider the fact that they're for hire. Sure, that makes a difference. Dr. Bodden, who came and told you that gravity doesn't work, paid over $100,000 in this case. He's very charming. He's very affable. I enjoyed seeing him in court, but hearing him was something else. Over $100,000 he got paid in this case. There was also a reference made to you. Mr. Darden began to address it about golf balls. You may recall. And then it was argued as well. It was argued that the defendant had that little dark bag that he insisted on picking up, and that was for carrying golf balls to the tournament in Chicago. Now, first of all, what kind of sense does that make? You take your own golf balls to a golf tournament? Don't you think they're going to give you some there? But it's worse than that because that's not what the evidence showed. Alan Park was specifically asked about that. Can you tell us, sir, whether you saw any golf balls in that lawn area that night? Answer, no. Cato was asked the same question. Did you ever see balls in relationship to a bag that was similar to the bag you saw in the driveway on June the 12th? No, I don't think so. I don't remember seeing that. I think there were balls in the garage, kind of just balls that were there. And that was a question asked by Mr. Shapiro of Cato Kalin. So not only doesn't it make any sense, but there's no evidence to support it at all. Now, there was something else said to you, represented, that Mr. Kalin and pictures and a videotape also refute. And that is a side door. You may recall that defense counsel mentioned to you, why would it be Mr. Simpson walking in through that front door when Alan Park was sitting out there watching him? He could have gone in from the side. Not true. And the evidence proves it's not true. First of all, Mr. Kalin testified that the laundry room referred to by counsel was not really used. But we have better than that for you, ladies and gentlemen. We have a videotape. We have that inventory videotape that counsel brought in that shows that door, that shows on June 13th that there were things, little step ladder and stuff like that in front of the door, which gives you a clear indication that door was not in use. And that's the condition of that area on the afternoon of June the 13th. Do we have a clip?
What exhibit is
Bless
this?
you.
What exhibit is this, Mr. Fairlaw? All right, thank you, Mr. Wood.
Whoops, back up. That was quick. Okay. Okay, see the laundry room in there? See that stepladder? You saw, what? See the stepladder? See the bag of laundry? It's stacked in front of the door.
Overruled. Counsel, it speaks for itself. All right, counter's at 3:01 PM. Thank you, counsel.
Thank you. Now, do you put a stepladder, do you put a basket of laundry in front of a door that you use? No, obviously not. So there was no other way in, and that is why Alan Park saw the defendant walking in the door that night. And I'm going to tell you something, ladies and gentlemen, that was the defining moment of this trial. That was the one. Because when you understand that the defendant was out that night, when you understand that he lied to Alan Park about being asleep, when you understand that that Bronco was moved and that he was out in that Bronco that night, and that 10:03 call to Paula Barbieri is because he was out there making that phone call, then you understand how the defense falls apart. Then you understand where he was when his whereabouts are unaccounted for. And Alan Park's testimony is unrefuted. Alan Park came in and told us the truth, and he told it consistently. Bronco was not there, and neither was the defendant until 10:54. Excuse me, the thumbs on the wall, 10:52. Now that's one more important point.
Overruled, counsel.
That's another important point, and this is why phone records are a good thing. And you'll have the testimony. I'm not going to read to you anymore. You're probably tired of hearing that. You have it in the record. I asked specifically, Cato, did you look at a clock? Did you look at your watch when you heard that thumping noise on your wall? No, I didn't. So is this an estimate? Yes, it's an estimate. He's estimating because he's not looking at what time it is. He says, I called Rachel around this time. About a half an hour later, I heard the thumps. It's an estimate. We had to go with that until we realized that Alan Park had a phone record. He had a phone record that said when he made a call and said when the call ended. And it was at the end of that call to his boss or from his boss that he saw Cato Kalin out in the side yard. And Cato Kalin told you, and it's unrefuted and it's uncontested, that it was 2 to 3 minutes after the thumping that he was out in that side yard. That's what he told you. And that means that the thumping occurred at 10:52. And then Alan Park saw Cato in the side yard at 10:54 at the same time as he saw the defendant walking in the door, 10:54. That means that 2 minutes after the thumping, the defendant is going into his house. And that means the thumping was done by the defendant. And they want to make fun of the fact that he ran into an air conditioner because it's his property and wouldn't he know better? Well, I don't think that he hung out on the South Pathway a whole lot. That's not where Mr. Simpson would go. That's where a repairman would go. Maybe a maid would go. He doesn't go down there. And anyway, that dark and that
Overruled.
that dark and that narrow little pathway in a hurry, when you're pressed and you're frantic, you're not going to be looking to see everything that's coming. You're running. He's in a hurry. And that's why that happens. Now, there was also some statement about there was nothing around that glove, but Dr. Lee said differently. Page 43,200. Question. Now, in addition to that, doctor, when you were at the Rockingham location, did you have occasion to find any item that in your forensic opinion was consistent or appeared to be blood in the area of the air conditioning unit near Cato Kalin's house? Answer, yes, sir. It's in the record, Your Honor.
Both. With the court reporter, please. All right, thank you, counsel.
It was also represented that Dr. Lee and Dr. Baden both agreed that the amount of struggle would have been a very long one. Dr. Lee, in fact, didn't say that. He said something a lot less certain than that. And I'll read to you what he said. Can you tell us blow by blow what happened here? Answer, no, I cannot. That's a good question. Question, all right, thank you. And doctor, would it be fair to say that if we cannot tell blow by blow what happened here, you cannot tell blow by blow what happened, then it's difficult to give any kind of a scientific estimation of time? Answer, that's correct. That's what Dr. Lee said. Now, with respect to Dr. Baden, it was represented to you that Dr. Baden said the perpetrator would have been covered in blood. That's not true. You can have all of Dr. Baden's testimony read back. I went and looked at it. It's not there. He didn't say that. He didn't say it. Not only that, but their own expert, Mr. McDonnell, had some interesting things to say about what kind of blood or how much blood you'd ever expect to find. As a matter of fact, we read the title into the record. Absence of evidence is not evidence of absence. This makes sense. A crime can happen in many different ways. Use your logic, use your common sense. If you're standing behind somebody, cutting their throat, they're bleeding out, and they're not bleeding on you. So you'll get some on your hands, maybe you'll get a little bit of spatter, but you're not going to be covered in blood, and you're certainly not going to be covered in the kind of blood that you're going to track into the Bronco because it isn't getting on your back. And that's why when you think about this, think about it logically, but don't let the record be misrepresented. You want it read back? They will do it for you. They will do it for you. And don't hesitate to ask, ladies and gentlemen. Don't hesitate. The most important thing is that you base your decision on what's there, what's really there, not on what some lawyer tells you is there, not on what you wish was there or I wish was there. What's there? I know you'll do that. Do you want me to break?
Yeah, take a break at this point. All right, ladies and gentlemen, we're going to take our noon recess at this time. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations till the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. We'll stand in recess until 1:30. All right, back on the record in the Simpson matter. All parties are again present. Jury is not present. Mr. Scheck, you wanted to be heard on page 43-200.
Yes, sir. A few things to say about that. First point to be made is that I think in Ms. Clark's argument, she started to say that there was a statement there was nothing around the glove, but Dr. Lee stated differently. Now she starts with the question, Dr. Lee, when you were at the Rockingham location, did you have occasion to find any item that your forensic opinion was consistent or appeared to be blood in the area of the air conditioning unit near Cato's house? Answer, yes, sir. That's all that's in the record at this point. Now, as the court noted at the bench, I would say there's three reasons, at least, that this was improper comment and that we should have an instruction to the jury, which is my request, that there is no evidence in this case Dr. Lee found blood on the air conditioner. And it's for at least these three reasons. Number one, there is a clear ruling in this case by this court that we've all had to live by, that presumptive tests are not admissible for showing that blood was present. And that is a clear ruling. There was a ruling that in the impeachment of Dennis Fung, that I had opened the door with respect to the Bronco, and the court made a limited finding that they could offer testimony about the extent of presumptive testing in the Bronco. So they know that that rule is in effect, and we've all lived with it and been very careful with it since. So that's point number one. Point number two, as the court noted at the bench, when one goes on to read the rest of the testimony of Dr. Lee in this area, the answers that were elicited were not that he had found blood on the air conditioning when Mr. Goldberg went on and continued asking him the question. And in fact, as I had noted on the record, and I'll get to the third point here, that he cut off Dr. Lee when Dr. Lee was about to give a further explanation when he indicated that he had done presumptive tests on the doorknobs, some sink traps, and air conditioner. And then Mr. Goldberg says, I'm just asking about the air conditioner. Answer, I saw in different places, and that's just about tests. And then Mr. Goldberg said, that's all right, Your Honor, I'll move on. I think he answered the question. Now, I came back the next day.
Is there a report by Dr. Lee that says that he did any testing there?
Yes, he did presumptive testing there. But I came back the next day, and it said 43380 of the record. And what happened, Your Honor, is that I indicated to the court at that point, have you read this?
No, I didn't. I don't have the 43380.
Oh.
Mr. Byrne, give me the next volume, volume 214, please.
Yes. I came back the next day, Your Honor. I think it actually starts at 43379. I came back the next day and made an objection on the record. And what I pointed out was that when I listened to I had thought that when Mr. Goldberg at this time, this is what I indicated on the record, said, that's enough, Dr. Lee, that what he was doing was trying to cut off the witness so there would not be testimony about presumptive testing, which would have violated the court's rule. And I thought that that's what he was doing. When I listened again the next night to the tape, because frankly, all these commentators were saying, oh, there's evidence of blood on the air conditioner.
You didn't really listen to those people, did you?
Well, no, I listened to the tape of the testimony. And when I listened to the taste of the testimony and the implication, I became concerned.
What page?
I think it starts at 43379 and goes on to 43380.
All right, proceed.
Do you see where I'm beginning? It's just before we took up the issue of the Furman tapes. Should I read it, or is the court's reading?
I'm reading it right now.
Okay.
All right, I reviewed the 43379 through 43381.
All right, so as that, I think, record indicates that I immediately approached the court and I said that I was fearful that, even though it wasn't explicitly stated on the record, that the prosecution might argue that there was blood found on the air conditioning from the way that questions and answers were brought out and the way Mr. Goldberg cut him off, and that I had misinterpreted Mr. Goldberg. He was cutting it off for purposes of putting this inference, which was improper in the first place because of the ruling on presumptive tests on the record, instead of trying to cut Dr. Lee off before he got into an area that was improper. And in fact, as I indicate in the record, that Dr. Lee was about to say that presumptive tests on sink traps, metal surfaces like air conditioners, doorknobs, and on that kind will always give false positives because of the nature of the metal surface and the bacteria, etc., which was what he was about to testify to, and they knew it because in interviews with Dr. Lee, that's what he had said. In any event, I won't, that's what Dr. Lee told me, and I offered to bring in an affidavit to that effect. And then the court indicated, as I put that objection on the record, and it was clear, and I thought, in effect, the court had ruled on that with respect to indicating to the people that that timely objection had been made on the record, and if they wanted to come forward and make this an argument, they were going to have to present arguments to the court that this was a fair inference from the evidence. I thought that's how the record stands right now. And they should, and this kind of comment, given the fact that the court had made a clear ruling in this case that presumptive tests are not proof of blood, number one. Number two, that the testimony itself does not support that contention. Number three, there was a timely objection noted on the record to the court, giving the prosecutors clear warning that if they wanted to make this argument, they better come in here and persuade the court that it was fair comment on the record. All of that being said, it seems to me highly improper and against the rulings of this court for them now to argue that there's blood on the air conditioner reading these questions and answers. It's not what the record states. It's not what the ruling this court is. It's misleading to the jury, and we're entitled to a curative instruction to the effect that there is no evidence that Dr. Lee found blood on the air conditioner. Highly improper argument, clear misconduct.
Ms. Clark.
I'm going to allow Mr. Goldberg to address it since he was the one that did the questioning. But I remind the court that the record says exactly what I read to the jury.
Thank you, Your Honor. Good afternoon.
Good afternoon, Ms. Goldberg.
The issue of presumptive blood testing is one that we've addressed on a number of occasions with Your Honor. And the state of the record was that presumptive blood testing does not come in. We have abided by that, although the defense has not. They asked Mr. Lee questions about the walkway with respect to parallel line imprints on June the 25th that he photographed. Those were presumptively tested. There were no confirmatory tests. Dr. Lee offered the opinion that they were blood, in his opinion, based upon his forensic knowledge, and was not specifically asked by counsel to testify that he had done blood testing and that that's how he knew. So he was basically relying on his generalized training and experience. It looks like blood, therefore it is blood. The basis for that opinion we know outside of the record is a presumptive blood test. That came in, the court allowed it in. Then with Mr. Bodziak, counsel asked again questions about Mr. Lee's presumptive blood testing and even called it that, blood testing, even though Mr. Scheck and I had an agreement outside the record that he would not raise the subject of presumptive blood testing with Mr. Bodziak without first clearing it with the court. And he just went ahead and did it on 2 occasions. I put before the jury the fact that presumptive blood testing has taken place. So I don't understand all the ins and outs and the exceptions and the rights and the wrongs with respect to the court's ruling. All I know is that it seems to be that when the defense wants to establish that something's blood, they don't seem to have difficulty doing it, even if the only basis for it is a presumptive blood test. And that being the case, we believed properly that we could do the same thing. Now, in this question that I asked Dr. Lee, I did not ask him about presumptive blood tests. I simply asked him, all right, now in addition to that, doctor, when you were at Rockingham location, did you have occasion to find any item that in your forensic opinion was consistent or appeared to be blood in the area of the air conditioning next to Cato Kalin's house? Answer, yes, sir. No question about forensic blood test. I'm asking him based on his experience and training as a forensic serologist, a very highly regarded one, whether it appeared to be and was based upon his forensic opinion. Then I asked him, and was that something that you believe that you thought appeared to be blood? Answer, I test some doorknobs, some sink traps, and air conditioner. I'm just asking you about the air conditioner. I saw in different places. Period. There's no indication from the transcript that I cut him off. And I said, that's all right, Your Honor. I will move on, because I was fearful that he was going to start talking about presumptive blood testing, which he had not to heretofore. He simply told what appeared to be the case and what his opinion was as a forensic expert. Now, the court has allowed police officers to come in and say something appeared to be blood, or I thought something was blood, or even something was blood. And we know California courts allow this, and Your Honor has allowed this in this trial. And I don't know why the world's perhaps most highly regarded forensic serologist, Dr. Henry Lee, can't come in here and tell us that something based upon his experience, his training, and his observations appeared to be blood. That's what this is. Now, as to the good faith belief, other than that it's in the record, and Dr. Lee has never been shy about trying to qualify and explain his answers. We also have a good faith basis because we have a report in which he said the same thing, that he tested this with orthotolidine test, which is highly reliable, which Dr. Lee regards to be reliable, and that it got a positive. I do not believe that I ever spoke to Dr. Lee about this question in my conversations with him at all. And that.
All right, Mr. Goldberg, let me ask you this. Did he indicate that he saw something that appeared to him to be blood, and then he tested it with orthotolidine?
In where?
In his report.
In his report, there was a red stain that he tested, and with orthotolidine test, and
on the air conditioner.
On the air conditioner, and it was positive for blood. So that was the good faith basis for my question. Now, on the as to the materials that are starting on 43-380 79 of the transcript, I was unaware of this, that this conversation even took place, because I was not in court during it, and was not aware until counsel made this argument during Ms. Clark's argument. I know how Your Honor has conducted this case, and I know, based upon the experience that I've had in this court, that Your Honor would not have ruled on an issue like this without my being here, and you did not rule, because this was my area, it was my witness, I knew this testimony, and I would be the person who was prepared to deal with it. Now, on 43-381, Your Honor says basically, well, Mr. Scheck says on 43-380, lines 27 through 28, I just want to make clear that we have an objection to that. And then Your Honor says, all right. And then on 43-381, lines 13 through 14, Your Honor says, this is a comment for the purposes of making a timely objection. I take it then, answered by Mr. Scheck, right, the court, all right, let's launch into the McKinney matter. And then you continue on with the 402 hearing on McKinney. So there is no ruling whatsoever with respect to this issue. If counsel wanted to make a motion to strike, I suppose that could have been done. We've closed evidence. We have introduced all of our exhibits. Ms. Clark is arguing about something that is in the record. She read it verbatim. She is entitled to do this under the court's rulings. And I do not see any basis whatsoever to prevent Ms. Clark from continuing on this line very briefly of argument. It's an important point because it's directly contradictory to what Mr. Cochran represented to this jury, and that she should be allowed to proceed on this issue.
First of all, it would seem to me that there's a clear question of waiver as to the whole argument he just made now, for a very simple reason. I came forward and put this objection on the record the next day, indicating that it would not be Dr. Lee's testimony that that was blood because of the false positives from testing sink-trapped strains, etc. And that would have been his answer to the question, and the record is ambiguous and misleading with respect to that because he cut us the answer. So I put them on notice. It is not an excuse that can be tolerated at law that somebody sitting at this table the very next day after Dr. Lee got off the witness stand didn't go upstairs and tell Mr. Goldberg that this was said so he could come back down and we could settle the record on this issue and it could be clear what could be offered in closing argument and what couldn't be. That is not an excuse. Lack of continuity in the district attorney's office or the fact that nobody will call him up so he can come down and argue this as though the rest of them here are incapable or don't understand this issue is not an answer. It's clearly waived. It is clearly waived. And what is particularly nefarious is that all of a sudden this issue arises during rebuttal. This is planned, Your Honor. It was exactly what I objected to. It is an unfair inference from the evidence. It is not supported by the record, even of the questions and answers, and it violates the clear instruction that we were all operating under here. It is in bad faith because I indicated that would not be the answer that Dr. Lee gave to the question. And it is quite different to be saying at certain points in time, I look at stain and I say, you know, the black imprints could be consistent with blood. And they can certainly make objections and settle the record at that point. I made my objection. I made it clear. The ruling was clear. It is outrageous for them to be arguing that this is blood on the air conditioner from this part of the transcript. When the record was made, their opportunity to correct it was there. They have to come into this court, and it's just outrageous.
All right. Thank you, counsel. The question was to Dr. Lee, did he see anything that, in his opinion, was consistent with or appeared to be blood in the area of the air conditioning unit near Cato Kalin's bedroom? And the answer was yes. And then the question later was focused back on the air conditioner, and the answer was, I saw in different places. And that's the state of the record. There is no mention of presumptive testing that was done. although Dr. Lee's answer just said, I test some doorknobs, some sink traps, and air conditioner. And I accept the representations of counsel that what was done is the orthotolidine tests. The fact that Dr. Lee, I think, is competent to say I saw something that appeared to me to be consistent with blood. The problem is that it was not confirmed. I'm going to direct counsel to move on from that topic. All right, let's have the jurors, please.
Montage for the defense that Mr. Cochran indicates he'd like to interpose an objection to. Let me indicate to the court that what it is a synthesis of evidence that has been admitted already.
All right, may I see it?
Yes.
Here's the first segment of the practice.
Hello?
He's O.J. Simpson. I think you know his record. Could you just send somebody over here?
Okay, what is he doing there?
He just drove up again. He just drove me over.
Okay, wait a minute, what kind of car is he in?
He's in a white Bronco, but first of all, he broke the back door down to get in.
Okay, wait a minute, what's your name?
Nicole Simpson.
Okay, is he the sportscaster or whatever?
Yeah.
Okay,
Thank you.
wait a minute, we're telling the police, what is he doing? Is he threatening you?
He's fucking going nuts.
Okay, has he threatened you in any way, or is he just harassing you?
You're going to hear him in a minute. He's about to go in again.
Second segment. That's the end, Your Honor. Five, please.
What is the connection between the audio and the montage? Is that the audio that you anticipate playing at the same time as the montage?
Yes. It goes in tandem with the argument that's going to be made to present it, which is the motive for the murder.
Do you think the tape directly relates to the last two photographs?
I'm sorry?
Does the audio tape directly pertain to the last two?
I'm sorry, the last.
The last two photographs?
Yes, that's the point. That's the case, Your Honor. That's the whole, that is it. That the motive for these murders
Okay.
is the nature of the problem, and that's why she wound up there. We're synthesizing the evidence. You know, we do it through verbal arguments, saying we have the motive, it carries forward and up till the date of June the 12th, and then we do it with pictures. Pictures that have been admitted in evidence. All of this has been admitted.
Mr. Cochran?
This is unfair. It's incredibly inflammatory. Those tapes have nothing to do with the photographs that are up there. If she wants to argue that, then so be it. This is improper rebuttal, Your Honor. They try to spring this on us at the last minute. The tape that she's referring to is a different time than the photographs. It's a photograph from 1989, tapes from 93, and the pictures, they try to link all these things together. They have nothing to do with this evidence. This evidence of other offenses was limited for a very limited purpose, and the court is aware of that. The reason it was in there, and this would be incredibly unfair and is typical of what the prosecution is doing in this rebuttal. This is outrageous, Your Honor. They're vouching, they're doing all of these things, taking things out of where they know they're wrong, yet they're trying to do this. At the 11th hour, when she has maybe an hour or so left, we're faced with this. This is outrageous, Your Honor, and you should stop it. They held this back, to keep us from dealing with this until the last minute. Now we see it at 1:55 on the last day of her argument. This is outrageous, Your Honor. The court should put a stop to it. This is the end of it, and we should get on and get this case to the jury. They're never going to stop unless you exercise your wisdom and discretion and stop it.
Thank you, counsel. Ms. Clark?
Your Honor, I don't think that Mr. Cochran has the right to use the word outrageous. This is a man who argued Mark Furman was commensurate with Adolf Hitler. This is the man who demanded jury nullification. But this is proper argument.
Let's address the issue.
Yes.
Are these items in evidence?
They're all in evidence, Your Honor. And the purpose for which we're using the tape being played over these photographs is the very purpose for which the domestic violence matters were admitted, which is for the purpose of motive and identification. And that's why it's been synthesized this way. I think we're using it to an entirely appropriate purpose, as the court has permitted us to do, with the jury instruction that limits it. We have, I think, appropriately argued it. Mr. Darden has appropriately argued in that vein. But this is argument, and we are synthesizing all of it. The domestic violence is the underlying theme in the case. It is certainly the motivation in the case, and it goes to identification as well.
All right, I think the record is not completely clear because we did not identify what all these items are, but what we started out with were photographs of the domestic violence injuries, the Polaroid photographs.
Yes, Your Honor, I should be more specific. They are the domestic violence photographs with respect to the 1989 incident. Then I believe they are the photographs from the safe deposit box. And then we have the photographs from Rockingham that pertain to this case, and they conclude with the photographs of Bundy pertaining to this case.
And this is while you're playing the first portion of People's Exhibit what?
What is the number?
This is the 93 tape.
It is both the 89 and the 93 tapes.
Your Honor, may I say something when you get an opportunity?
Ms. Clark, you concluded with your argument?
Yes, Your Honor.
Your Honor, in the 93 incident, as you're well aware, the tape they played, there was only the French doors were damaged. There was no physical anything. In the 89 incident, they ran these two things together. They have nothing to do. They're juxtaposing. This is an interpretation they're placing on the evidence. If they want to show the evidence, that's one thing. But to play the tape in conjunction with that, that's a production from the district attorney's office at this 11th hour, and it's unfair. It's absolutely unfair. It's inflammatory. This is improper rebuttal. We've seen all this evidence in addition to that. The court has told us on several occasions you're going to stop us when there's redundancy, and this is absolutely redundant. It is improper. The prejudice far outweighs any probative value because they're meshing things that don't follow. They do not follow. This evidence was limited for a limited purpose, and they're tying things together and making a conclusion, just as she did with this incident regarding the air conditioning. And that's unfair. Vouching for things, it's wrong, Judge, and it shouldn't happen.
Is that the word for the day?
Vouching?
Yes.
Vouching is the word for the day, Your Honor.
Thank you.
The I word, and it's personally vouching, and it's wrong, and they know it's wrong, and everybody knows it's wrong, and it shouldn't happen, Judge.
Ms. Clark, I do think it is a problem with the soundtrack because you've run the two soundtracks together, the 89. Is this two tapes?
Both of which have been admitted.
I understand. It's misleading because you can't tell that they're two tapes. There's no break with them.
Well,
is
I'll
my
tell them.
concern.
How about if I tell the jury we're running them together?
When do
Then
you anticipate doing this in your argument?
at the end. I'll introduce it. I'll explain to the jury we've run the two tapes together, and as I have to tell them what they're seeing and hearing. I don't want to mislead them. I want to tell them the truth. I want them to know exactly. I want them to hear exactly what it is that they're hearing. I want them to know. That's the 89 tape, and then we're going to run the 93 tape, and we're going to run the pictures from 89. We're going to run the pictures from the safe deposit box. I want them to be very clear about what they're seeing and hearing. I don't want there to be any mistake about it.
All right. With that caveat, the objection's overruled. All right. Let's proceed. Let's have the jury, please. Ladies and gentlemen, please be seated. And let the record reflect that we've been rejoined by all the members of our jury panel. Good afternoon again, ladies and gentlemen. And Ms. Clark, you may continue with your concluding summation.
Thank you very much, Your Honor. Good afternoon, ladies and gentlemen. I forget where I left off, so I'm just going to pick up with something else. There were some remarks made about the treatment given to some of the witnesses, and I confess that there are probably some I could have been nicer to. Mark Partridge came in to testify to the defendant's demeanor when he came back from Chicago, and this kind of it's a really good example of what I'm talking about. He made notes, detailed notes the next day, you might remember, of everything that the defendant said to him and everything that he said to Mr. Simpson, and he copyrighted them. He copyrighted them. What does that mean? That means you have a proprietary interest in the material. The very next day after he speaks to him, he's going to sell these notes. He's going to make some money off of this. He's got some proprietary interest in this. Now, what kind of a man is that? What kind of a person is that? And it's very indicative. It's very, very consistent. You heard from Ellen Aronson. She came up to testify. She was the one, she said, she called into the police to say that she initially said that she heard the dogs barking at 11:30. Then she saw the preliminary hearing and she realized, I better call back again and change the time so I can make myself a witness. You know, a groupie. And yeah, I don't like that kind of person. That doesn't belong in a criminal trial. That's the kind of person that's going to...
Sustain. Counsel, rephrase that, please.
Okay. That's the kind of person that will offer any testimony they can to get their 15 minutes of fame. That's not the kind of testimony you can trust. At the end of the trial, or at the end of the people's case, we had or maybe it was the whole trial, the judge took judicial notice of something. And I'm sure you were wondering, what does that relate to? And the judicial notice that he took was that the moon on the night of June the 12th was a crescent moon, 12% illuminated. You may recall that. That's very important for two reasons. First and most important reason is it tells you what the lighting conditions were like that night. It was not a full moon. It was a dark night. Witnesses, their testimony has been referred to by Mr. Darden, have confirmed that it was dark. Officer Risky made it very clear it was dark. Sukru Bostepi, who was walking with the dog, who said, I would not have looked up there. I wouldn't have seen the body if the dog had not stopped and looked up the pathway. That's important. So you have that judicial notice taken. That means it's an undisputed fact you are to accept, a 12% crescent moon. When I cross-examined Ms. Aronson and I asked her what was the moon like, oh, it was a full moon. Are you sure? Yes, I'm very sure. It's in the record. Have it read back. She was very sure. She was very wrong, too. She also testified that she was very sure that she called the police officer to give her statement to him the first time on June the 14th. I showed her the police report. It said June the 15th. Are you sure? I'm very sure. She's very sure about a lot of things, but one thing she really didn't know was when she was walking down that street. And you know how else you know that she wasn't down that street when she said she was? Because Mark Storfer said he looked out his window at 10:23. I read it, and I reviewed it, and now I'm so tired I can't remember it exactly. You can have it read back because I think that what he said was 10:23.
Excuse me, counsel.
In any case...
There's some objection. Please stop.
I'm sorry. I didn't hear.
All right. Cap. Remember, you're the judge of the facts. You're the sole judge of the facts. Thank you, counsel. Proceed.
Yeah, and you know, if you have a doubt about something I'm saying, please have it read back to you or look at your notes, okay? Because I'm not trying to play fast and loose here. But it was within 2 minutes of when she passed Bundy that he looked out his window. If she's walking down Bundy and that lights-colored outfit that she said she was wearing on that night, he should have seen her when he looked north on Bundy, because he said he looked out the window, looked north, and he saw no one walking there, which is actually consistent with the other witnesses who don't say that they saw anybody either. All of the witnesses that were called by the defense somehow were in the same place, but none of them saw each other. It's very weird. Defense has raised the issue about there being, why wasn't there dirt? Why wasn't there mud at Rockingham tracked in the house on that light carpet? There wouldn't be. You saw the bloody shoe prints, and they faded out halfway down the Bundy walk, to the point where there were no visible bloody shoe prints on that walk at the end of the walkway. Then you saw the imprint in the Bronco, so that whatever blood was left on the shoe was picked up by the soft tufts of the carpet. By the time he gets back to Rockingham, there isn't much left there. Whatever blood, whatever mud, whatever dirt he's got on his shoes, he's tracked off. This is common experience, you know. Your blood or mud, whatever you get on your shoes, doesn't stay there forever. You walk, it comes off, and as you walk, more comes off. By the time he gets home, there's not a lot of excess there. Maybe there's some trace amount, but you're not going to notice that on a carpet. And so that in itself says nothing. And the testimony of their experts, Mr. McDonnell, I think even Dr. Lee, does not dispute that. Of greater importance,
Overruled.
and I think actually, yes, Dr. Lee even testified. He was asked specifically, if somebody walked through dirt, walked through berries, would you necessarily see it? And his answer was, you might see it, and you might not. The absence of evidence is not evidence of absence. And that's what their witnesses have said. Now, there was an issue raised with respect to EAP. That's a conventional blood marker, okay? And you may recall there was testimony that Nicole Brown had an EAP type of BA. The blood under her fingernails was typed and came back with an EAP of B. We had testimony from Greg Matheson to indicate to you that that was degraded, that the BA degraded to a B. In order to confirm that it was her blood and not the blood of someone else, they did DNA testing on that blood. And the DNA confirmed that it was hers. It was her blood, and that it had degraded. And it had degraded because, number one, the EAP marker degrades very rapidly. Number two, her hand was in wet blood, and blood in a wet state degrades quickly, more quickly than it would on a dried gate, for example, or in a dried condition. Now, there's more to that. First of all, Gary Sims agreed with Greg Matheson in his conclusion that the blood under her fingernails was hers and not that of another perpetrator. But the
Overruled. Excuse me, counsel. You need not make that objection any further. I've instructed the jury that they are the sole judges of what the facts are in this case. And if counsel chooses to argue a line of argument that is in contradiction to what these jurors find to be the facts, they do so at their own peril. The objection is made. Thank you. Ms. Clark.
Thank you. Moreover, Dr. Lee, who was called by the defense to testify, never contradicted that. And he agreed that Greg Matheson was a good scientist. There was some testimony, I think, from Dr. Bodden that you can get somehow the blood of someone under your nails without getting the skin under your nails. I don't see how that can possibly happen, but what is interesting...
Overruled. Overruled, counsel.
What is interesting is that the defendant's EAP type is also a BA, also. Now, the blood on the rear gate, that blood that came back to the RFLP testing, making the defendant 1 in 57 billion or something, obviously it's an identification. That's his blood. There's not even any dispute about that. That's his blood on the rear gate. That blood also had an EAP that was a BA degraded to a B. That blood also...
Hold on. Counsel, with the court reporter, please.